their turn, beginning with Joseph Clark, attorney for the Secretary of State.
The difficulty that we have here is not really a legal problem, it's a political problem. We have a two-tiered process in Florida as far as election returns are concerned, and that has to do with, first, the counting and the certification of ballots, and the second is the contest. And most of what you are being asked to deal with today is the problem that is created by the contest. And if you think about it, it creates an enormous number of problems as far as the court is concerned, a number of which have been addressed by the different justices.
The concern that I have is that it's not, that we have a long-standing policy out of other courts of this state that say that the real parties in interest here are the voters. Now, what I want to know is that and this 112 has a provision which says that some voters' votes may be ignored. And what I am concerned about is in what is the boundaries on which the Secretary or the Commission could exercise its discretion and have those voters ignored. And I pose to you that in this particular presidential election, doesn't it revolve around the electoral college and the fact that the prejudice that's involved here is the prejudice of not allowing Florida's votes to get counted?
Well, Mr. Chief Justice, the beginning point here is that there are 6 million voters, of course, and the focus here is on 72,000 of them in 3 selected counties. The Attorney General started out by saying that the Attorney General's position is that all the votes in the state of Florida be counted, but that, of course, is not what is underway at this point. The problem with respect to the electoral votes in Florida only occurs if the status quo is maintained, if the votes cannot be certified, if the contest procedure cannot begin.
One of the issues was whether the Secretary of State exercised discretion in deciding not to certify hand-counted votes received after the Tuesday deadline. Her attorney said she did.
She sent a letter out. She asked for the reasons. They provided the reasons by 2 p.m. on the day after, on Wednesday, I believe, and then she promptly responded after applying them against a set of criteria that she had developed to exercise her discretion.
When did she develop those criteria?
You're asking me as a matter of fact, Your Honor? Starting within probably an hour after Judge Lewis entered his decision, she asked for input on the kinds of criteria that would be appropriate for her to exercise her jurisdiction.
Is that rather unusual as for a way for an agency head to come up with a decision in this state to just come up with something within a few hours as to whether to allow something or not allow something?
Well, Justice Pariente, I was kind of refreshed because the agency had actually asked for legal advice on it and what the legal standards would be for her to properly exercise her discretion, and she was pushing against a deadline, so I considered it excellent, frankly.
But she didn't really exercise her discretion. What was said was that a reason that she was not going to recognize as a reason for late filing manual recounts being conducted in accordance with 166. That was no discretion exercised. It was in accordance with her prior legal decision that recounts that were not based on machine errors were not going to be allowed, and that was what she announced the day before.
Well, Your Honor, the decision that the opinions that come out from the Division of Elections, Mr. Roberts' group, is not exactly the Secretary. The Secretary is the one that had the obligation under the statute to exercise her discretion in this case.
Why wouldn't it be, in this unique circumstance, a better thing to do to wait and unless there is a specific reason that's going to prejudice Florida's certification to the Electoral College, wait and see to a point in time when the manual recounts are completed. Allow those amended certifications to be made, and then there will be a point in time in which a determination can be made as to whether the contest in respect to those are going to jeopardize Florida's electoral vote.
On behalf of people, there's no suggestion anywhere here in the record that we have a problem with the voting machines or there was any fraud or anything else. What we're trying to do is to deal with the problem of people who did not follow instructions. The instructions were to put the stylus through the hole in the ballot. They did not follow those instructions. Now, balanced against that, it's being suggested that the entire contest period should be stood on its head and that the Secretary of State loses her ability to conduct her constitutional exercises.
We've had cases dealing with this issue in Florida since the 1800s, and all of them in some way, shape, or form come about because voters do not follow the instructions. And in all of those cases that I have read, when you can look at the ballot, even though it is improperly marked, and even though the voter did not follow the instruction, but you can tell the intent of the voter from that ballot, that vote has to be counted.
And Mr. Justice Harding, I would suggest to you that all of those cases that you have seen have been a voting contest. And the difficulty we have here, as I say again, the court is being brought into something it need not be brought into. This is not a legal problem. This is a political problem.
Governor Bush's attorney, Michael Carvin, emphasized the importance of adhering to a deadline.
May it please the court, as the colloquy today indicates, there is a very clear procedure for resolving all the questions that the justices have asked, and that's set forth in the statute. You set a firm deadline, and you make sure that everybody gets their votes in at the same time, and if there are any problems in terms of voter tabulation or the kinds of questions that we've done, you've got to keep to that deadline so you'll have time to do the election contest after that.
Let me roll my initial concern I stated by you, but will tell me when Florida's certification would be in jeopardy if the certification is not made by that date.
Well, it's clearly in jeopardy now, but I mean,
why is that?
December 12th is the cutoff date.
Why is it in jeopardy now?
Because if they're not certified, then there is no way to come to an accurate statewide count. And that, as we've seen over the last 10 days, is an enormous undertaking. So if we continue to delay the certification process, remember that deadline is not the end of the process for finding accuracy. It is the beginning of the process for finding accuracy.
4 of the 7 justices must agree on the court's written ruling, which could come as early as tomorrow.
Decision 2000 from NBC News World Headquarters in New York. This is NBC Nightly News with Tom Brokaw. Good evening. It was a nationally televised lesson in the rule of law and the intellectually vigorous disputes that are required to settle it. In Tallahassee today, lawyers for Vice President Gore, Governor Bush, the state of Florida, and Palm Beach voters engaged in more than 2 hours of forceful arguments and faced skeptical questions from the Florida Supreme Court. Tonight, that court is trying to decide whether the votes now being recounted in 3 heavily Democratic counties must be accepted by the Secretary of State. The association will be settled by the Florida State Supreme Court. Who are these men and women who have such a pivotal role in history? Here's NBC's Pete Williams tonight on the court.
In a state where Republicans run the governor's office and control both houses of the legislature, Florida's Supreme Court is the only branch of the government with the Democrats in charge. 7 justices, each appointed by a Democratic governor who chose from a list submitted by a nonpartisan state commission. And a former Chief Justice says this is a court accustomed to making tough calls, including life and death decisions in capital punishment cases.
Of course, who the President of the United States is going to be is of utmost importance. But then again, so is taking the life of a human being.
Who are they? All experienced lawyers. 2, Chief Justice Wells and Fred Lewis, never served as judges before. Lewis, the son of a coal miner. Peggy Quince, daughter of a longshoreman. Harry Anstead grew up in a public housing project. 2 on the court, Chief Justice Wells and Barbara Pariente, were active contributors to the Democratic Party before they came to the bench, giving a combined total of over $6,000. Conservative activists claim the current court tends to vote on the liberal side, for example, frequently blocking voter initiatives from getting on the ballot.
They've taken 19 citizen initiatives and thrown them off the ballot, and no state court in this country of the 24 states that allow citizens initiative have done that.
But on this most political of cases, many legal scholars say the justices will set partisanship aside.
These are not political hacks. They're not the result of a partisan political election. And I think once these judges have taken the robe and joined the court, they have left politics aside.
30 years ago, the Florida Supreme Court was not widely respected. Two of its former members tainted by scandal. Now among the nation's best and facing the country's most pressing legal question. Pete Williams, NBC News, Washington.
Now how this looks to Brooks, Broder, and Oliphant. David Brooks of the Weekly Standard, David Broder of the Washington Post, and Tom Oliphant of the Boston Globe. First, Tom, just in general terms, what was your impression of the hearing today?
I thought it was remarkable. If ever there were an argument for allowing television cameras in the where Supreme Courts meet, whether it's federal or state, here you have it. Also, I thought the argument was very important because it enhanced the reputation of this Supreme Court, which is already considerable in the country in legal circles. But I think their careful questioning, their willingness to go really into detail and betray a very thorough understanding of the case already has enhanced their, at least, potential of delivering a decision that will provide a roadmap for the country. Now, they still have to do it, but I thought the hearing today was an excellent beginning.
David Brooks, an excellent beginning?
Yeah, I thought it was an outstanding day. Finally, somebody is in charge. We've had these weeks of partisans and spinners and hacks. All these people who would spin their grandmother out of the Thanksgiving turkey that would help them win this election. And finally, somebody, and it seems the justices were grappling with the serious issues, not only who was going to win this election, but the long-term issues, the central issues of authority. Where does their authority come from? Where does the Secretary of State's authority come from? Where does the Florida legislature authority come from? So these were long-term issues, which were really a reassertion of some sense that somebody's in charge, that the whole process hasn't run out of control.
David Broder?
I've never seen these 7 men and women before, Jim, but it struck me that they are a very confident group. You didn't get any sense that they wished that this were not on their doorstep. They look to me like people who are prepared to take charge and to try to make some sense out of this real hash of a situation.
You know that they established, at least took a step today toward establishing a credibility, so when they do come up with a decision, that both sides will have trouble moving on from it?
Well, I think that's right, but it's also very clear that they are prepared to say and indeed assume that their word will not be the final word. What was really striking to me was that, beginning with the Chief Justice in his first question, they started working their way backward from that December 12th date when Florida is required to choose a set of electors to cast its 25 votes in the Electoral College. And they seem to assume that whatever the determination that they or the Secretary of State make, there will be further contest of that. So my impression is that they think we're going to go right up to that December 12th deadline before we get a final answer from Florida.
David Brooks?